Good evening, everyone, and welcome. Thank you for joining us this evening for our environmental law webinar in honor of Earth Day. Happy belated Earth Day to everyone. I'm Niki Memarzadeh. I'm the Legal Education Director for the Iranian American Bar Association's DC chapter, and I have the distinct pleasure of serving as the moderator for this evening's webinar. I want to provide a little bit of background about IABA before we get started for anyone who may not already be aware. IABA's mission is to educate our community about legal issues of interest to Iranian Americans, to protect and advance the rights of Iranian Americans and other minority groups, to promote and foster the achievements of Iranian American legal professionals, and to fundraise for law student scholarships. This year, IABA is putting on a series of legal education webinars and in-person meetups, so please follow our various social media channels to stay engaged. And before we dive into our presentation, I have a few housekeeping remarks to ensure that we just have a productive conversation this evening. So please, I see everyone's on mute. Thank you. Please continue to keep your audio muted for the duration of the webinar, and feel free to submit any questions you have in the chat box, and I will read them throughout the presentation or at the end, just depending on the flow of the conversation. Please note that this webinar is being recorded and will be uploaded to our YouTube channel. So if you know anyone who wasn't able to join, or you just are so enthralled you'd like to watch again, that will be available for your viewing pleasure. I want to emphasize that the information being shared tonight is for educational purposes only and does not constitute legal advice. If you require specific legal advice, we strongly encourage you to consult with counsel. And additionally, to any extent that views are expressed, they are the views of the speaker and not of the organization. And now, without further ado, it's my honor to introduce our distinguished speaker for this evening and my friend. Emma Shahabi is an associate attorney for the Northern Rockies Regional Office at Earthjustice, which is the premier nonprofit public interest law firm bringing environmental and energy cases throughout the country. She works on high impact litigation at the federal level and under state constitutional law and with local communities. Though Emma now lives and works in Bozeman, Montana, she spent her first year out of law school in DC, working for the U.S. Department of Energy, and returns to the DMV often to visit family and friends and enjoy great Persian food. She was at Davish over the weekend. I'm sure many of you have been. And we can't wait to have you back. But in the meantime, we're so happy to have you here virtually, Emma. Thank you for joining us this evening.
Thank you so much, Niki. It's great to be here.
Well, I want to we have so much to discuss. I want to go ahead and kick things off. So I think just giving, I don't know how many environmental lawyers are on the call, but I'm certainly not one. And I think it's just helpful, to understand the landscape that we're operating in. So what are the main kind of statutes and frameworks relevant to environmental law?
Sure, and I'll try to keep this broad strokes, but a lot of our environmental law and our statutes are based on sort of a core group that was passed in the 60s and 70s, and actually a decent amount of them under famous Duke Law alumni Richard Nixon. But those include sort of the well-known statutes, Endangered Species Act, Clean Air Act, Clean Water Act, and sort of that main group. And there's also a substantial number of slightly more niche statutes, and you get something like the Outer Continental Shelf Lands Act or some of the waste statutes, Wild and Scenic Rivers Act. So there's plenty of those as well that kind of delve into those more niche subject areas. I'll say that also environmental law is very heavily intertwined with administrative law. And a lot of that is because environmental regulation and enforcement is most often occurring under the executive branch, and that's through agencies like the EPA, NOAA, the Bureau of Land Management. So you see a lot of administrative law statutes impacting that as well. And then lastly, I'd be remiss not to mention state and local governance as well, and especially the state that I currently live in, Montana. We have a constitutional right to a clean and healthful environment. So we do see a lot of state and local laws affecting environmental work as well.
I'm so glad you brought up administrative law, because I think that's one of the issues that we're all kind of more highly attuned to, given everything that's going on in the news and recent coverage around Supreme Court cases dealing with the administrative state. So following recent Supreme Court rulings that have limited, the role of the administrative state, how has the legal landscape changed for environmental law? Are we seeing a shift from the federal regulatory framework to state level, like you said, or even private litigation to enforce those rights?
Absolutely. And I think there's sort of two parts here. And I think, when we talked about this last time, we mentioned the major questions doctrine. So I think that's one big shift. And then we can touch on enforcement as well, because that's sort of another big shift that I'll point out. But the major questions doctrine that was sort of explicitly established in 2022. So actually under the previous administration. And again, in broad strokes, that essentially is addressing statutory interpretation with regards to agency action. So the doctrine basically limits agency power, and it requires that uh, agency authority, there has to be sort of explicit authority in that statute, in the environmental statute. So, in the context of environmental issues, again, we're looking at these statutes that were passed in the 60s and the 70s that, may not have even considered some of the issues that we're addressing today, like AI and data centers or emerging nuclear technologies. So we're working with those statutes that are decades old, but we're also working with a Congress that, uh, isn't necessarily it's not prepped to be amending these statutes or passing new statutes. So the major questions doctrine, especially under the previous administration, was certainly restricting kind of agency authority for any issues that, quote, were affecting major political or economic significance, which again could be sort of any realm of environmental issue. And I think we certainly did see a shift in sort of agency reasoning and also legal arguments in the wake of that doctrine. But also, I'll clarify that the doctrine, again, was primarily used to limit agency authority. So when we were dealing with the previous administration, I think we definitely saw some environmental efforts and efforts to regulate STEMID. Now that we're dealing with this second Trump administration that sort of favors deregulatory action, this doctrine has become less adversarial to environmental advocates, and even in some contexts is a tool that we're considering to use. For example, if the Trump administration is using, emergency authority to bypass regulations or sort of agency overreach in that context, maybe that's a tool that we would consider using on our end.
Yeah, I think deregulation is something that's just been so top of mind, and it's like trying to drink from a fire hose, keeping track of all the deregulatory action that's been going on. And something that, many people may have missed is that a couple months ago in February, the EPA moved to rescind the 2009 greenhouse gas endangerment finding. Can you explain the legal significance of this rescission and how it impacts the government's duty to regulate climate harming emissions?
Yeah, absolutely. And I might give a bit of context here because I think this is, again, not something that if you're not in the field, you would necessarily be paying attention to or even understand how it fits into this broader scheme of environmental work. So, quick context, the endangerment finding is sort of a part of this broader process surrounding the regulation of greenhouse gases. And the process began with a petition in 1999, and that was by environmental groups asking the EPA to regulate greenhouse gases from motor vehicles. And this petition was under Section 202 of the Clean Air Act, which basically authorizes the EPA, if they find that a pollutant from a motor vehicle endangers the public health or welfare, then the EPA has to regulate it. So these environmental groups brought this petition basically to ask the EPA to say, hey, greenhouse gases are a pollutant that is endangering society, so you should be regulating this. And there were a few years of this petition kind of hanging out there in the abyss, and then eventually the Bush administration denied it. And the litigation resulting from that led to Massachusetts v. EPA in 2007. And that's sort of one of our hallmark cases in the environmental field, and that essentially found that greenhouse gases are pollutants. And again, EPA has to evaluate whether they would endanger public health or welfare. And that led to that endangerment finding in 2009. So that's sort of the process that led to this finding. But once the EPA had that finding, they used it for a variety of other rulemakings, all having to deal with greenhouse gases. And so that kind of affects every part of our life. And that's power plants, vehicle emissions, oil and gas, landfills, kind of anything that has to do with greenhouse gas emissions that would affect the health and welfare. So the repeal of this rulemaking, not only affects the endangerment finding itself, but also all of these other rules that are relying on the endangerment finding. And as far as legal implications, those rulemakings aren't automatically reversed by this proposed repeal, but EPA is also working on reversing those kind of based on the repeal of this finding as well. So this was passed in February, and I do want to just shout out the org that I work for. This is not my team specifically, but some of the wonderful folks in our DC office it basically filed a challenge to this repeal immediately after it was published by EPA. And
Wow.
in sort of a funny story, we have a lot of partners in that case, and some of our partners are in Europe. And so the EPA published this proposed repeal around 4 in the morning Eastern time. And because we had partners ready to go, they actually were able to file the challenge to the rule, I think within 10 minutes of it being published in yeah, in the Federal Register. So trust and believe that Earthjustice was on this with again a plethora of other organizations because this is such an impactful rule, and we're seeing partners across the country and again across the world as well.
So that case is currently before the district court in DC.
Yeah, so there's several petitions that we filed challenging that proposed rulemaking, and the different petitions bring in different groups who it affects. So some of these partners are, for example, Union of Concerned Scientists, and then we also have communities and we have tribal nations. So truly not just geographic diversity, but also diversity in background as well.
So I think, to say that environmental law is not going to be an enforcement priority for this administration is pretty clear. So in an era, excuse me, of reduced federal enforcement, how does the citizen suit litigation from private parties kind of fill that gap that's left by EPA enforcement and DOJ? And because they're not really going to pursue these cases.
Yeah, we truly have seen sort of an unfathomable drop in enforcement, or at least something that even in the last Trump administration, we weren't seeing these sort of numbers. And that's a drop in enforcement primarily by the Department of Justice, but also, other environmental agencies as well. And if I can share one stat that I know off the top of my head, in 2025, in the 19 days before President Trump took office, the DOJ issued $590 million in fines. So again, this is before Trump took over, just the first 19 days of the year, $590 million in fines. In the following 11 months after Trump took office, the DOJ issued just $15 million in fines across just 20 cases, I believe. So substantial drop. We're seeing that continuing into 2026. And again, substantial numbers that we didn't even see in the first Trump administration. So instead, DOJ is either not bringing these cases or, pushing them into pretty paltry settlements with these corporations that oil and gas corporations that see fines like that as paying a parking ticket as opposed to actual deterrence for polluting actions. So that's absolutely a real issue that we're seeing across NGOs. Earthjustice actually established a separate team entirely devoted to enforcement, in part because we've seen such a lapse here, and that was something that Earthjustice established just this past year. That's headed by Laura Toms, who a fantastic attorney, former DOJ enforcement. So we're also seeing a lot of federal government attorneys kind of shift over from the federal agencies to the NGO side in the wake of this second administration. And of course, myself included in that. I was formerly with the Department of Energy and then moved to Earthjustice last June, actually. So certainly seeing an increase in efforts and in action by NGOs, citizen suit litigation has been and continues to be incredibly important, both for restorative justice and to hold polluting entities accountable. And like I said, with real penalties and deterrence, and not just a slap on the wrist. So I think we're seeing a lot of creative litigation to fill these sort of governing gaps. And again, not just with federal statutes, but at the state and local levels as well.
I think, while the environmental area is not an area of priority for enforcement. Somewhere we have seen them very focused on enforcement is with DEI and ESG. And the current administration has explicitly targeted DEI and equity frameworks and ESG frameworks. So, how do you adapt your legal arguments for environmental justice in a climate where these terms are being removed from federal guidance and are almost like red flag buzzwords?
Yeah, I think that is a really interesting question, especially because I think the DEI and ESG policies you see sort of throughout every level of environmental advocacy. So it's not just at the legal challenge, and so it's actually I would say I experienced this difference or this impact a little bit less so on the litigation side, and I see it more so in grants, in programming, and also in any sort of partnership between the federal government and, federal programs, state programs, local communities. So this is something that I actually saw back when I was with the Department of Energy, and that was right around the time that they were starting to roll back these initiatives. And essentially, my understanding of how the federal government is rolling these back is really at a superficial level. So any sort of mention of terms that are considered DEI terms or anything related to race, to socioeconomic status, to different identities and backgrounds, they'll target and either reject grants, deny them, or even just remove programs based on that. So we're seeing not really a lot of critical analysis of these initiatives, but just flat out rejections. And so because of that, I think programs and communities are really having to alter their strategies on how they're describing their work. So even if it's the same program, not mentioning DEI, not mentioning race or any sort of, I would say, flag word or trigger word that would cause a rejection to these programs. And I think not only is that a problem with efficiency or even accuracy, but it really does stymie some of these important programs that are targeting, again, restorative justice. So we're seeing that at the science level, where certain important research is not being conducted, and that's something that I, as a litigator, also rely on. We're constantly using underlying studies and papers and research that if we're not able to access those, we can't make the lawsuits that we're making.
And something that the courts are increasingly relying on in the wake of Loper Bright, not being able to defer to the agencies at the level that they were before. These are extremely technical areas of the law, and you really rely on objective scientific expertise to understand these issues. So to the extent that that research is no longer being funded or isn't available, I mean, it's going to have a major trickle down effect, excuse me, on the courts. Um, yeah.
100%. Yeah, no, and I'll just point out too that you mentioned Loper Bright, which again provides more deference to agencies, and the idea is that when there's real technical issues. For example, I have a case that I'm working on related to grizzly bears, and we get real in the weeds of grizzly bear science. And obviously, that's not something that I was necessarily well versed in prior to the case. It's not something that the judges are well versed in. So they want to be able to rely on studies and accurate studies. But if you're taking that in the context of, for example, maybe a tribal issue, and the federal government is deeming that a DEI issue, then all of a sudden you don't have that research to rely on. And you're relying on judges, again, who don't have the expertise, who may be trying their best, lawyers who don't have the expertise, and we're just not getting the most effective results from that.
Kind of taking a step back, more from a bird's eye view, could you talk a little bit about the concept of environmental justice and restorative justice, and why having that intersectional framework in a field, in a very technical field like environmental law, is really important?
Yeah, I think it really depends on where you're kind of approaching an issue. So from the legal side, I personally do have a science background just in my undergraduate degree, but I'm by no means an expert, like I said. So we do rely on having partners who can look at an issue and kind of pinpoint some of the main points that we want to bring up in our legal challenges. So to give a quick example, if we are getting an environmental analysis for a project and they're going through and touching on, let's say water quality issues, I may know enough to flag, hey, there might be an issue, with this section of the analysis, but I'm going to want to bring in an expert to be able to touch on, exactly what these standards mean and everything, and give us the basis for our challenge that maybe that analysis is inadequate. So again, bringing that diversity in background is so huge because we're relying on all of our partners to be able to have the expertise where we're dealing with a variety of issues. So we can't necessarily be experts in every single one.
Yeah. Just with the role, like the precision of the use of terms like DEI and ESG, there are major gaps like the ones you've identified. And I think, there are going to be communities that kind of slip through the cracks. And how, and there's a discrepancy between state laws, like, Montana has, the state constitution, like you mentioned, has those protections. There are plenty of states that don't. So can you speak a little bit about how the lack of a cohesive federal strategy is going to lead to inequity between the states and, disproportionately impacts different communities?
Absolutely. I think what it comes down to, maybe there's two layers here. One, you have, of course, you mentioned the difference in state regulations and local regulations. And you have some states with, constitutional rights. You have some towns who are prohibiting. I know, for example, in New York, there's a town that just passed a moratorium on data centers, right? So you have maybe in a bluer state, you have laws like those that are being passed, but we're not seeing them being passed in, for example, Tennessee, where Elon Musk just established a new data center without following any regulations. So you do see this discrepancy where some states are going to be holding groups accountable and other states aren't, and you don't have the federal government to even that playing field. I think you're also just seeing a discrepancy in resources. So working for an NGO, we're one of the bigger NGOs, I would say. We still have limited resources and we can only address certain issues. And, if there were 10 more of me on my team, we would love to pick up as many cases as possible, but there's always going to be limits to resources. And so there's always going to be some cases that we and our partners can't really take on. So I think that's where you start to see smaller issues slipping through the cracks, and specifically in the DEI context, just underprivileged communities that don't have the resources to be hiring private counsel, that have to rely on public interest groups, and especially if they're not receiving any grant money or any other contributions from, again, the federal government. So that's where you really start to see these communities being overburdened and strained even more so than they already are.
I want to kind of totally switch gears because I know we're the IABA, and I know there are a lot of there are a lot of Iranian Americans on the call, and a topic that's been weighing on everyone's hearts and minds for the last couple of months is the war in Iran. And we're all, I think, very attuned to the human level impact, how it's impacted the people, how it's affecting the infrastructure. But there are major environmental ramifications of this war. Could you tell us about what those ramifications are, in any war, and specifically what we're seeing on the ground in Iran? And, just tell us a little bit about that aspect of this war and its impact.
Absolutely. And I want to stress while we're talking about the environmental issues that this is, of course, all in addition to all of the really, horrific consequences that we're seeing of the war. And I do hope that everyone joining is, safe and their families are safe. And my hearts go out to everyone. I do think there are a few layers to the environmental issues here. Of course, there's the actual motivation behind these types of geopolitical conflicts. And I think for decades now, we've been seeing that a lot of the real motivation behind these geopolitical wars is resources like oil. So it is an environmental issue, and the fact that our dependence on fossil fuels contributes to these wars, just starting these wars and continuing these wars. And we've seen that with this war in Iran, both in the past and now with the strait being closed, and was sort of a huge, I would say, maybe the central point of the ceasefire talks, and that again surrounds our dependence on oil. So you see that sort of in the motivation for the war and continuance of the war, but we also see the direct impacts as well. And that's when it comes to bombing of infrastructure like oil refineries and power plants that, again, we've seen in recent months. And aside from the, obvious horrific impacts on citizens who are losing access to power and essential resources, we're also seeing the explosions from those attacks and the fallout, including, really awful pollution and carcinogens in the air. I think most folks have probably saw the sky after those attacks and sort of the smoke that was coming from them. You can just tell by looking at it that that's, going to be awful for any of the civilians in the area, and contaminated water, and again, long-term fallout as far as cancer, and any sort of respiratory issues. And again, all of this falling on civilians. So not only the environmental impacts on the ecosystems, but also on public health as well. And then lastly, I would say also seeing impacts back in the US. And that's, again, in light of closing the strait and seeing calls from US politicians and energy sector to increase domestic oil production. And that's something that we see time and time again claimed as a national security issue. And it's a real roadblock to the US's transition away from fossil fuels and transition to renewable energy. And so I think as these wars continue and as these geopolitical conflicts continue in the name of oil, not only is it affecting citizens in Iran and here, but we're also seeing it affect our transition as well.
I think is it true that when the government frames, the production of domestic oil as a national security issue, that allows them to bypass a series of regulations and just, things, safeguards to keep the environment safe, to make the production safe. But if it's an emergency, they're able to bypass those. Isn't that true?
That's 100% correct. And I'll flag that this is a really worrying I guess, impact that we're seeing in the second administration, both in this context and I'll say across the board as well, is that the second Trump administration is using emergency authorizations far more significantly than any other administration we've seen. And the impacts of that is that we are losing whatever remaining environmental statutes and regulations that we have to protect against these processes. So we've seen it in the oil context. There was a recent decision in Southern California where, in Santa Barbara, offshore oil drilling was opened up again as a result of emergency authorizations as a result of the war. So we're seeing, highly destructive offshore oil drilling that's happening. There was also recently the Endangered Species Act has sort of a committee that is called informally the God Squad, and the God Squad is called into play when an endangered species is threatened. The God Squad can basically overrule that threatening and say, despite this, despite the act, we're going to do this action, right? And that's, again, in broad terms. But the Trump administration has recently rolled out using the God Squad to exempt the entire Gulf of Mexico, offshore oil and gas drilling, from these endangered species concerns. So we're seeing it at a broad scale. This has never happened before, and it's incredibly concerning. It's incredibly concerning for the environmental context, but also for the sake of our administrative checks and balances. There's a reason that these laws exist, and using emergency authorizations to kind of bypass those, I think, is problematic on so many levels.
Absolutely. And another area where I've seen the waiving of the ESA and NEPA and things is in the construction of the border wall, which is something that, prior to reading about this, I hadn't thought about the environmental impacts of immigration law and the border wall. Can you speak a little bit about, I know we didn't talk about this one before, but it just occurred to me. Can you speak a little bit about kind of the environmental impacts of major public infrastructure like a border wall, like a pipeline, things like that, and the use of emergency authorizations in those contexts?
Yeah, absolutely. And I think we are seeing this more and more today that there is so much intersection between these environmental issues and some of these other social justice issues. So we talked about it in the context of the war in Iran, but also, like you said, in the context of immigration. So with the border wall and also with, I would say, a lot of these immigration detention centers that are popping up with ICE these days. And that's something that my organization, Earthjustice, and other partner orgs are really trying to address head on as well. I think we're all coming to the realization that you can't address these issues in society just with one tool in your toolkit. So you can't come at it just with the immigration toolkit. You need also the environmental statutes as well. So, Earth Justice brought a case recently with the Everglades Detention Center in Florida. And so, Earth Justice with other partners brought this case under environmental statutes. So while this was an immigration issue, the original injunction was achieved under NEPA, which is the National Environmental Policy Act. And the premise of the case there was essentially that in creating or in building this detention center, that the proper procedure and environmental analyses weren't conducted. So the agencies broke the law there by just building this detention center within months. And of course, that's an issue too, in that you've got inhumane conditions and it's problematic on all these levels. But the injunction was able to be achieved under the environmental law. So I think that's a wonderful example of we're seeing these issues be intersectional and that they're bypassing environmental regulations to achieve these horrible results, but also we're seeing sort of folks using environmental tools to stop them as well. And I think we need that kind of across issues.
Yeah, I think for anyone who didn't know anything about environmental law before joining this call, I've learned so much. Just I feel like we've covered a lot of ground, and I think that illustrates the point that this touches every aspect of our lives and of the law. It intersects with everything. So I'm sure this has galvanized a lot of people on the call to want to be involved, either if they want to be an environmental attorney, if they're a student, or they want to find a way to incorporate this into whatever their practice is. How would you suggest somebody gets involved in environmental law if their background isn't in science or policy or environmental studies?
Yeah, I think I mentioned this earlier where, some of us do have backgrounds in science, but we come across issues every single day where we still have, barely a fraction of the expertise that we would need for those issues. So I really don't think that that is a barrier of entry to getting into this field. I think the most important factor for becoming an environmental lawyer is really just a passion for the issues, and for the communities, because I think if you have that, the substantive knowledge will follow. You basically just need to care enough and then have the will to put in the work. And figuring out the subject area expertise is far less important. So that would be the biggest factor, I would say. If you're a law student who's interested in getting involved, there are so many great opportunities in law schools that I would recommend, especially if your school has an environmental clinic. That was one of the first, actual environments for me to do environmental work, and I had the best experience. So I would recommend that. If you're in the field already, I would also say don't be too scared to transition into different subject areas in the law. I have several friends who were actually, I had one who was a labor attorney and she came to Earthjustice, and then I have another friend who was working as a public defender and then came over. So I think again, it's really just caring about the people in the communities, and especially as we've mentioned, so many of these issues touch on different sectors of the law. So truly, I don't think you need any sort of environmental expertise to do this work and to do it well.
So as we're starting to wrap up, I want to encourage anyone on the call, if you have any questions, please drop them in the chat. Oh, here we go. Here's one. Um, So someone asked, military conflicts often expose the limits of international law in constraining state behavior. So in the environmental context, where international environmental treaties rely heavily on voluntary commitments, do we see similar structural limits in effectiveness? It's a great question.
That is a great question. I think absolutely yes. I think, international law is not my expertise per se, so I, obviously defer to the experts there, but I will say there are several international environmental frameworks, and they do touch on issues, for example, like transboundary harm, and they touch on issues regarding pollution and endangered species. But I will say they face the similar the similar enforcement issues that we see in some of these other frameworks. So, for example, with the war in Iran, we see frameworks that would address some of these issues, like the pollution and transboundary harm. But we also see frameworks that would say, you're not allowed to bomb civilian infrastructure, or you're not allowed to bomb hospitals and schools. And we're seeing that happening anyways, right? So I think you see very similar limitations to specifically with regards to enforcement of these frameworks. And I will say where I have seen success in enforcement of international environmental frameworks specifically, typically involves some sort of economic enforcement, and it also typically relies on countries who have more influence and power. So, for example, when the US decides to enforce an environmental international framework, they have had success in the past doing so. If the US decides not to, or decides to actively go against, it's very hard for some of these other countries to try to enforce the frameworks despite all members, being parties.
We have another couple questions from the chat. One of them is, if you're familiar, why has it been so difficult to achieve meaningful regulatory change in Cancer Alley, which refers to areas of the Deep South like Mississippi, Louisiana, where cancer rates are significantly higher than other places, despite decades of documented health concerns?
That's another great question. And I think it touches on what we talked about a little bit earlier with the disproportionate protections for especially underprivileged and marginalized communities. And I think when we're looking at the context of Cancer Alley, and again, Deep South, you're looking at states that do not have the same state level protections. And there's a lot of agency capture, just because a lot of these states, for example, Louisiana specifically, has a huge portion of oil refineries and petroleum-based industry. So these industries are a massive source of economic, growth in GDP for the states, and so the agencies are not choosing to regulate them. What you're left with there is, local communities fighting for their communities, but not having the power to do so at a state or federal level. And then again, organizations that are overstretched and overburdened in trying to protect these communities. So I think why we've seen such a struggle is probably a lot to do with lobbying. But also, I think when we're removing all of these DEI protections, you're taking all the tools out of the toolbox for these communities. One route that I've seen used in this area is, Title VI lawsuits and challenges, and so that's under, the civil rights context. I think that's it's a really amazing way to not use an environmental statute, but using civil rights work and discrimination laws to achieve the same result. So I think we're starting to see more of that, but again, there are really roadblocks at each level there.
I kind of want to follow up on that and ask, if you could explain, the concept of environmental racism, what that refers to, and whether that framing of an issue you feel like is helpful in advocacy or not.
That's a good question. And I think a good reminder maybe to take a step back on some of these issues. It's easy to get into the weeds on them. Environmental racism is sort of referring to the intersectionality or the overlap between racism and environmental issues, right? So we're seeing compounded effects in marginalized communities, both as a result of structural racism that then compounds environmental effects. So if you have a community, for example, in Cancer Alley, that maybe they're forced to live in areas of town that are, less expensive because again of, structural poverty. So they're living in areas that are less expensive where there's a lot of industry. They're not zoned for just residential housing. They're zoned for factories. And so then they're going to be right next to all of these emissions. They're going to be disproportionately getting cancer because of these factories in this industry. And again, we're seeing that overlap between the environmental pollution and the poverty that's imposed by the structural racism. So we see this a kind of across context. So that was a good example with Cancer Alley. But we also see it with, for example, Native American tribes. And that's something that I work on a decent amount here in Montana. But a lot of Native American nations have had their resources exploited through mining. And then mining companies will come in, destroy sacred sites, destroy natural resources by reservations or on reservations, and then leave decades behind of water contamination and carcinogens, with again no real accountability towards the companies.
We have one more question from the chat. How has Earthjustice addressed Loper Bright in terms of litigation strategies? So are you relying more on expert witnesses and depositions, et cetera? And kind of a follow-up question to that, or separately, have you noticed any opposing groups trying to say that the environmental statutes do not have a private cause of action? And she notes that she's seeing this happen in the voting rights context. So she's curious if it's, you're seeing it in the environmental law context as well.
But both great questions. I think in terms of Loper Bright, I there's been sort of definitely shift in strategies, but I will say that Loper Bright actually removed some deference towards agencies. So in the context of the Trump administration that is pushing deregulatory action or action that would, be seen as contrary to environmental conservation efforts, that removing deference is actually, again, it's could be considered a positive.
A
So,
blessing in disguise.
sorry,
A
go ahead.
blessing in disguise.
Yeah, exactly, exactly. So we're seeing shifts in strategy there, but actually seeing more shifts in how the agencies are presenting their own rationale and reasoning, right? So uh, the new standard is that it has to be the best interpretation, right? And so an agency doesn't have the ability to rely on their previous interpretations and have to come to the court with a more built out record. And that's where I think, Yalda, you mentioned expert witnesses and depositions. We're going to be building more facts into the record and having doing that at every point in the process. So during comments, during any sort of notice period, we're going to be building in facts into the record. And less so during the actual challenge, because again, if we start getting into an expertise battle, the judges don't want any part of that, because they don't want to have to deal with those studies. So that's sort of the shift we're seeing there. As far as the cause of action, I would say we are seeing an impact to standing. And this is something that we're seeing challenges from both the administration, but also from other groups as well. So sort of contrary private groups or organizations or firms. And they are targeting standing in the environmental context to say that, maybe it's an injury issue, to say that uh, your injury as a plaintiff needs to be more concrete. There needs to be a stronger nexus, and especially in the context of environmental harms, to say that we rely a lot on organizational standing, to say that if our member has standing, then our organization has standing. We also rely a lot on recreational interests. So if a member is using an area to go bird watching, that should be enough of an interest to have a stake, right? We are seeing attacks on that. And so one way that we're responding as an agency or as an organization is to really augment our standing and complaints and otherwise. So we're going very in detail for our standing declarants, which I personally love because, our standing declarants are our plaintiffs. They're the individuals that we're bringing cases on behalf of, and talking with them is one of the best parts of my job. So, adding more details on their behalf is something that I'm always happy to do, but the fact that other groups are trying to limit our ability to bring lawsuits based on that is the real threat and the real issue.
Well, Emma, thank you so much. This has been so helpful and comprehensive. And, we're just so lucky to have a member with your expertise and passion in our community. I kind of want to leave things on one, hopefully hopeful note. I think everyone who's been on this call was either interested in environmental law before. If not, they certainly are now. So what's one thing that we can all do to support Earth Day this year, besides obviously joining the webinar, but that's not enough. We got to do more.
Yeah, I think the most heartening part of my job is really working with the people in these communities, working with my coworkers, and even doing webinars like this and getting to connect with people who care. So I think paying attention is, the number one thing I would recommend. Paying attention to these environmental issues. Like I mentioned, everything is so connected. It could be easy in the light of all of the horrors that we're kind of experiencing right now to let some environmental issues fall through the cracks. But I can't stress enough how important all of these issues are to our everyday lives. So continuing to pay attention and continuing to get involved at all of these levels. So at the federal level with issues like the endangerment finding, at the state level, and even at the local level, I'll shout out there was a community in Virginia recently where the city commission approved a data center in their community, and the town was so upset that they voted out half the commission in response. I think that's real power. I think people have real power at all of these levels. And so, it's our responsibility to recognize that and to use it.
Just, asking for myself really, because like you said, there's so much information. How do we keep track? Are there certain like accounts or outlets that you rely on, for good environmental news, like Instagram accounts or anything like that? We should all follow Earthjustice, but beyond that, is there anything that you recommend? Just off the
Yeah,
top
I
of
appreciate the shout out for Earthjustice. Another Instagram account I love is Intersectional Environmentalist. That's a great one. I also would say if you are looking to get kind of a little bit more educated on the issues, Politico has some great newsletters that I get in my inbox as far as environmental issues. And also, I'd really encourage finding in your, whichever city you live in or whichever neighborhood you live in, connecting with your local grassroots org. And these are the orgs that we're working with every single day. We as the lawyers work with the orgs, but the orgs do the real work of connecting with community members. And so they'll send out news of what's happening, what's being approved projects wise in your neighborhood, in your town. And they do a great job of saying, hey, you can submit a comment on this, or you should show up to this hearing to really take that burden off of individuals and get the community involved.
Awesome. Well, Emma, thank you so much for your time. And thank you to all our participants for joining this evening. Just wonderful chatting with you, like always. And you're just a wealth of information, and we have so much admiration for you. So thank you so much, and happy belated Earth Day, everybody.
Thank you so much, Nikki. It was a pleasure. I will also throw my email in the chat. If anyone has questions or wants to connect, I'm always happy to. And thanks all for joining. This was so much fun.
Thank you. Have a great night, everyone.